Park, Colleen Ford, and Katie Moore for the Executive Director.
Good morning, Your Honor. Eric Holman, legal counsel David Frederick here on behalf of Drive, Trinity Drive, Comal Creek, South Wisconsin, Vulcan Quarry, and for purposes of the hearing, we're also representing Harrison line.
Good morning, Your Honor. Jim Mehta for the Office of the Business.
Great, thank you. So we have a motion that was filed, two motions that was filed on Friday the
these are citizen groups set up in surrounding the areas surrounding proposed Vulcan Quarry. You have heard there are basically two standards that must be met in order for TCEQ to issue a permit. Those standards set out by the legislature. And those are 3.0518 subsection B. Now clearly there's a whole cascade of additional laws that flow from those, but that's kind of the linchpin of what the permit system is about. B1 requires that the applicant demonstrate that it uses best available control technology to reduce best available control technology. The second is that the TCEQ not find a reason to question whether there might be adverse impacts to human health, and to the property. So there is, you will hear throughout, I think, this hearing, some debate about how the best available control technology decision is made. I think there's no real dispute between the parties as to the fact that Texas has a different standard for the ACT and the federal government. But once you acknowledge that threshold question, then there's a whole series of questions that flow from that, having to do with process issues to implement those standards. And the position you receive from us, the protesters, is that Vulcan has followed TCEQ's process and turned to a sort of checklist of matrix for rock crushers and said, okay, in the past, TCEQ did this and that together by way of improving the ACT, or by way of improving controls for rock crushers. So that's all we have to do this time. That, we think, is not what best available control technology is, but they have followed the process. Which basically is, I think, I described. There's a list, and they're list to see what they have to do. There is then the issue, after you cross the ACT threshold, which is the ACT prong of what has to happen in order for a permit to be issued, we have the issue of is it protective of health and public property. Now, there's pretty significant dispute between the parties as to what one does about considering sources of emissions that are not themselves facilities. As you probably both know, the statute does provide, as was explained by Councilor Vulcan, that only facilities have to be permitted by TCEQ. Facilities do not include quarries or hallways. From that, both TCEQs have another policy, now it's got this policy under which TCEQ currently operates, and the policy under which Vulcan operated before this permit application, was that, well, since haul roads and quarries and the pollution that comes from those is not part of a facility, then we don't have to consider it when we consider what the off-site impacts, the cumulative off-site impacts of the facility plus all the other sources of pollution that will be. We don't have to consider those quarries and haul roads. Now, as you may know, if you receive the testimony from the briefing testimony, this is an area that has quite a number of quarries and rock crushers. So there are quite a lot of facilities out there, and at least one rock area facility within 10 kilometers of the proposed Vulcan site that have not only a rock crusher, for which you can go to TCEQ's records and look up the maximum allowable emission rate table and pull out some emission rates and plot those emission rates into the permit. But those quarries and rock crushers also have haul roads and other sources of dust that are not considered, well, that should be. The protesting position is that should be considered. TCEQ's position and Vulcan's position is that they don't have to be considered because they're not facilities. We think this is illogical, or compelled by the law, and in fact undermines the second prong of that 382.0518B test that I described to you at the outset. Is this protective of health and property? I think on the crystal silicon issue, that's been briefed a good bit to you already. That there is an issue. The crystal silicon is probably the air contaminant that is most concerned to people in the vicinity of this quarry. And you're asked to take on faith And your orders today have supported that, ask, that, the silica content of the limestone that will be crushed is 0.2% by weight. We're allowed to see no documentation supporting that, no well logs, no photographs, no nothing. We just take it, and TCEQ took it as true what Vulcan said. And maybe even that's Vulcan's best estimate. But Vulcan could have made errors, there's all kinds of things. It'd be worth exploring if you're really going to determine what the silica content of the limestone is. So, many of the things that protesters want relate to enhanced monitoring. Protesting position is they've given the almost stack of information about what the silica content of the limestone on the Vulcan property really is. Increased monitoring is a fair and reasonable thing to make, be part of the permit. And then finally, and I'll be quiet, I think you hear a lot that, Vulcan's main defense, and TCEQ's main response also, the criticism that has been raised thus far in this case by protesters to the process by the companies, is, well, we follow TCEQ's practice. TCEQ's got guidance that says this. TCEQ didn't just wait for some other rock pressure. Take, for example, the issue of whether you would include any dispersion following the atmospheric model. Those sources of emissions that definitely exist, they're real world sources, but they're not facilities. And the sort of practices, we don't look at those. You will see, I think you'll see, because it's very probably already, that TCEQ simply refused to review the dispersion modeling that, Vulcan actually did do, that included some, but not all, of these non-facility sources. The reason for doing this is basically is for the waste. So, you're gonna hear a lot of testimony to that, we follow TCEQ's guides, we follow TCEQ's rules. There's no rule against what we did, and I think you're gonna have to make a decision whether those are really, are those convincing supports for a process that you might otherwise think wasn't watching. That's basically what our case will be, I think we'll finish with the case.
Do you have anything?
No,
All right, Mr. Kim? Good. We've already submitted.
Your Honor, I believe, when this was.
Right, that's right. Okay.
Circulated last week.
Yeah, right.
Before we get to the witnesses, I want to just remind everybody that air conditioners on site behind our heads. So be sure to speak somewhat loudly, don't let the rest of the speakers intimidate you, not speak loudly. We obviously want to make sure that we're here, make sure that we are.
Yeah, so we have a minute to administrative record, preliminary hearing, so we begin with Mr. Kim.
That'd be correct.
Mr. Butler, are you taking that word?
Yes, ma'am.
And then you, okay, present. Okay, Mr. Beckman.
So,
When you're ready. like in general, we can't.
We can't do anything.
In general,
In general.
nothing exact.
We'll have to just, everyone try to speak up a little bit more directly into the microphone.
And this is an example, this is a copy of what we're about to do. This was exhibit 105. That was the supplemental testimony that was filed Friday, that I believe I understand from, for Mr. Gephardt, that I believe I understand from the initial order is, you had admitted.
Well, we haven't admitted it yet, because it hasn't offered, but we have overruled the objections.
So, having gotten this far, Mr. Gephardt, can I get you to review that document that was marked exhibit 100? Just look at it enough to convince yourself that you know what it is.
So exhibit 100 is my refiled direct testimony.
And then can I get you to look at what's been marked as exhibit 105 and see if you're able to confirm what that is?
Exhibit 105 is a supplemental direct testimony that I had prepared for this case.
So, Your Honor, for that, I would move to introduce into the record, Friends Exhibit 100 and 105.
Okay, and objections having already been dealt with, exhibits 100 and 105 are admitted.
Mr. Gephardt, if I were to ask you today various questions that have been asked in Exhibits 100 and 105, would your answers today be the same as the answers that are reflected in those exhibits?
Yes, they would.
With that, Your Honor, I would pass Mr. Gephardt for cross-examination.
Do you want to include 101 and 102, 103, 104?
We probably should do that, yes, we should. So, does your pre-trial testimony have attached to it the exhibits? Which is to say 101, 102, 103?
Yes, there are various attachments to my refiled direct testimony, which are following exhibits behind exhibit 100.
Okay, so, in your testimony, which is 100, exhibits Friends 100, I'll represent that you have identified each one of those exhibits, 101, 102, 103, 104. Is that correct, you remember?
Yes, my recollection is that the various exhibits, 100 through 104, are referenced in my direct testimony.
Okay, in light of this, Your Honor, I would go ahead and move the introduction of exhibits 101 or 104, as well as exhibit 100 and 101.
And again, objections have already been taken care of. Exhibits 101, 102, 103, 104 are admitted.
And then I would pass the witness for cross-examination by cross-examination.
So I believe it begins with Ms. Method.
Good morning, Mr. Gephardt. My name is Pranjal Mehta. I'm an attorney representing the Office of Public Appeals Counsel. I have a quick question for you from your pre-trial testimony. Can you please go to page 13 of your pre-trial?
Okay, I'm ready.
Can you please read for me lines 5 through 11?
Starting with line 5. First, although Westward did model some of the road emissions, the modeling still omitted emissions associated with the quarry, including the road emissions linked to the hauling of aggregate materials within the quarry itself and from the quarry to the crushing and screening plant. The only road emissions that were considered were those from hauling of the output from the crushing plant off-site. So Westwood modeling is incomplete from the perspective that it captured only part of the fugitive dust emissions that could adversely
instead omitted from the modeling, or the ones which are already considered in the modeling? Which one would have higher impact on air pollution in this case?
I think that's a difficult question to answer because the fugitive dust emissions, which are not included in the modeling, have not been quantified. And so I don't have any reference point to compare the two, because you have data on one hand and you have no data on the other. So it's very difficult to make a judgment as to which one might be worse from the standpoint of public health. I think in order to be a complete analysis, even to make a claim that the modeling is protective of the National Ambient Air Quality Standards, you have to address all relevant emissions from the project, and that was not done in this case.
Thank you. I have no further question.
Mr. Hsu?
Thank you, Your Honor. Mr. Mayor, we're going to that during the deposition. I want to ask you a few brief questions about your experience in air permit in Texas. So you guys should bring up this one here, put it on the paper, page 2, I'm sorry, page 3.
Page 3.
Page 3 lines. See there that question regarding your experience in working on facilities in Texas?
Yes, I do.
What was your answer?
My answer was that I was the project manager responsible for securing an air permit for a corn ethanol production facility located near Plainview, Texas.
And that was the White Energy Project, that reference here.
Right, I believe at this time the plant is owned by White Energy, but I worked for a previous owner of the plant.
And how long ago was your work on the White Energy?
Thinking it's 10 years or more.
10 years ago. Do you have experience working on any other air permitting projects in Texas?
Not where I was a lead person, I may have done supplemental review or assistance, but Plainview plant, I was the project manager, and I can't recall any other instances where I was the project manager of their project.
Do you recall any of those other air permitting projects?
I don't recall any other air permitting project.
Is your experience in states other than Texas involved estimating control technology or back?
Yes, it does.
And does your experience include back reviews under EPA's top-down back review process?
Yes, it would.
Are you familiar with Texas ACT review process, the three-tier back review?
In general terms, I agree with Texas, the ACT process.
In general terms?
That's what I said.
Do you know if TCEQ has any guidance documents regarding TCEQ's three-tier back review?
I believe they do, and I believe my recollection is that I reviewed that in preparation for this case.
So do you know when you reviewed that applicant, when you reviewed TCEQ's ACT guidance document?
Would have been in preparation for this case, so it's back in the last agenda.
That you completed your review within a couple of days of when you recall your testimony?
I completed my review as part of preparing the refile testimony.
Do you recall in the deposition, we can go through it if you'd like, when you had answered one of my questions, that you were still reviewing the back guidance document just a few days before the refile testimony?
I believe that's how I answered the deposition question. My analysis was in process at the time of the deposition.
So you hadn't reviewed TCEQ's back guidance document before that time?
This project is the only relevant project in this work where Texas needs to be done.
So did you have the back review
No questions, Your Honor.
Okay, Mr. Frederick, Mr. Feedback?
No, Your Honor, I don't think so, thank you. Actually, I think Mr. Allman is going to take charge for my next case. Let me look into it.
For this, it's called Dr. Thomas Snyder.
Dr. Dye, will you raise your hand, please? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you.
Good morning, Dr. Dine. Do you have for testing exhibit 200 is the evidence to award
Don't see them are numbers, but
Is that material compared to this one you had in the
yes, sir, it does.
And if I were to ask you those questions today, the answer to your questions, do you have any changes or corrections?
Yes, I do have one change.
Can you walk through that?
Certainly, sorry. On page 13, beginning with line 4, that part of the testimony talks about emissions from the diesel fuel storage tanks that are proposed at the Vulcan facility. And in that testimony, I said that they have not evaluated the potential impact for the annual average impacts of diesel fuel vapors coming out of those tanks. That was an inadvertent error on my part. The applicant actually did do that. So I need to take that part of the testimony out.
And is that page 13?
Next, page 13, starting with line 4 and going through line 15.
So with the removal of that particular testimony, is this the testimony
Yes, sir, it is.
and you also have the verbally in the supplementary testimony here?
I do.
And is that testimony the testimony you gave today?
Yes, sir.
And that, Your Honor, testimony about where it says 200 kilograms.
Objections have already been addressed, exhibits 200, 201, 202, and 203 are admitted.
And Your Honor, that we passed.
I have a question.
Mr. Seal?
Your Honors, after reviewing the record, we're satisfied with the result of the tests are concerned with Mr. Adams.
Okay. Mr. Marcos?
No questions, Your Honor.
Okay. All right, thank you.
think you will find that Friends 300 has attached two other Friends 301 and Friends 302. So if I get you to look through those two documents you have in front of you, and confirm, well, tell us, look at it, figure out if you've seen those things before, what they are, and then confirm that they also are attachments which are exhibits 301 and 302. Judges, am I correct, you already have copies of these in your file?
We have copies of the file on what you presented to.
Not some. Well, let me give you a copy of Friends 303 and some.
Your Honor, just for clarification, 303 is some of the things, including the following on the file.
That's correct. Okay, Dr. Collins, can you tell us what is Exhibit 300?
300 is my big document.
And then attached to that, there are two more exhibits. Can you look at those and tell us what is 301 and what is 302?
There was my CD. 302 is my preliminary results.
And when you say that's your preliminary results, am I not correct, that's an excerpt from a preliminary results report from those 5 years? And then what is Exhibit 303?
Exhibit 303 is supplemental testimony on the courthouse.
Right, thank you. Be sure to speak into the microphone as much as you can. All right, now if I were to ask you today, the questions that are asked in Exhibit 300 and Exhibit 303, would you have the same answers today under oath that you had during these pre-file testimonies were prepared?
Yes.
Your Honor, with that, I would move introduction of Exhibits 300, 301, and 302. With that, Your Honor, I would move introduction of Exhibits Friends 300, 301, 302, and 303.
And exhibits 300, 301, 302, and 303 are admitted. Do you have a question?
Your Honor, after reviewing the individual record, we're satisfied that the pre-file testimony and pre-file testimony concerning Dr. Collins' testimony.
Mr. Martin?
No questions, Your Honors.
Going to offer the other ones that parties way across on Mr. Franklin, Mr. Harrison, and Mr. Stoner, Rigby, Mr. Ray, is that correct?
Let's see here, we've got testimony from Mr. Harrison, Mr. Culler, Mr. Rigby, Mr. Rhea Ray, and then Mike and Terry Olson.
Along with Mr. Everett.
And, yes, and certainly along with Mr. Everett. None of those people have supplemental testimony, and all of them, as I understand it, agreed to those parts.
Okay. So, would you like to go ahead and open it?
Yes, I would like to.
Okay.
So, Your Honor, at this time then, I would offer the pre-file direct testimony of Mr. Don Everingham, which bears exhibit number 400. I would offer the testimony of Mr. Michael Fuller, which actually bears no currently marked, at least my copy doesn't bear a currently marked exhibit number.
Do any of those others,
From the Harrison Group, I'm just checking as we go, I don't believe we either have, they've not, first place, they've not been given exhibit numbers, and I'm checking to make sure that they have no attachments. So that would be then that I would move to introduce into the record, exhibit 400 through exhibit 404, Mr. Everington's packets.
Okay.
And the remaining, the testimony then of the remaining 4 or 5 Harrisonburg witnesses, 5 Harrisonburg witnesses that we discussed earlier, but for which I don't know what. I would presume we would start out with exhibit Harrison 1 through 5.
Okay. Okay. Do that.
So Harrison would be, Doug Harrison's testimony would be Harrison 1. And then Mr. McCullough's testimony would be 2. Harrison 2. Mr. Rigby's, or really his wife's testimony would be, exhibit 3, Harrison. Jeffrey Reed would be Harrison exhibit 4. And Mike and Terry Olson would be Harrison exhibit 5.
So exhibits so the current exhibits 400, 400, 401, 402, 403, and 404 are the Harrisonburg exhibit 1, 2, 3, 4, and 5 are the
All right, thank you.
then that would be just.
That concludes the case of the protest report.
Okay. It seems a little early to take our morning break, so why don't we go ahead and get started with all of it?
Your Honor, welcome all, Mr. Gary. Your Honor,
Ready to talk for our first minute?
Mr. Nichols, we have one of your binder, on the front is entitled Vulcan Construction Materials LLC, file Texas Week, volume 1, Gary Nichols. So you can open, that binder, and just walk through that with me.
Okay. I'm waiting to start. That's okay. Will you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay.
So, Mr. Nichols, the binder that you have in front of you there, you recognize the exhibit that's behind the first tab, is entitled APG. If you turn to the last page of that exhibit, it's base number in the bottom right-hand corner, APG 736. Is that an affidavit that you signed there? Yes. If you could just turn real quickly through the next tab to APPGN2, you recognize that document? Mr. Nichols, if you were to testify live here today, this conditional testimony. Yes. Your Honor, with that, we would move to enter into the record APPGN1 and APPGN2.
Exhibits APPG and 1 and APPG and 2 are admitted.
And Your Honor, with that, we would ask.
Okay.
Thank you, Judge. Mr. Nichols, good morning. You have the floor, correct? So let me get you to look at your exhibit, your pre-file testimony, and internal page 16 of that testimony. And there, if you will look at lines 10 through 13. I want you to read those just for yourself. There are a couple of questions. Okay. So my first question is, that your conclusion reached in that sentence, am I not correct, is based on two things principally. One, the silica content, crystalline silica content of the limestone that Vulcan proposes to crush. That's one thing. And then second thing is the modeling results based on 1 year of meteorological data that are reflected in the air quality analysis.
Your Honor, that's a comment question.
Can you break that down further?
Certainly I do. Am I not correct, Mr. Nichols, that one of the variables that supports your statement that you read there in lines 10 through 13 is the silica content of the crystalline silica content of the limestone that Vulcan proposes to water and dry and crush. Well, let's start at the top. Your statement there, am I not correct? Is a statement about the health impact, if any, or the impact on property, if any, of crystalline silica in the emissions from the rock crushing facility. Yes. And in reaching that conclusion, am I not correct that you relied in part on the crystalline silica content that Vulcan has sponsored to be the content of the limestone that will be crushed in that facility?
Yes.
Okay? And another variable on which your conclusion is based, am I not correct, is that the appropriate meteorological data were input to the dispersion model that generated the outputs during all meteorological conditions. And in this particular instance, that is 1 year's worth of meteorological data, correct? You don't know?
Speak up, where's the mic, please? Okay, well, let's, raise your hand if you can't hear instead of interrupting. Okay, let's try to do that, let's not interrupt. So, hold the microphone a little closer, I'm sorry, we can't really raise the volume anymore. If someone wants to try to move maybe that seat, might hear a little better than over that way. Okay.
So maybe I'll restate the question. Mr. Nichols, do you not know whether 1 year's worth of meteorological data were the data that you used for dispersion modeling or the off-site impacts of the crystal facility?
I believe that's true, but as I said, I can't monitor myself.
I understand, but you believe that modeling to have been done correctly? Yes. Do you therefore also believe that 1 year's worth of meteorological data was the correct decision to make about how much meteorological data to use?
The decision about how much meteorological data to use is one question. First, particular dispersion model. And I believe in some cases, it's trying to that we some cases, I believe this is
Well, when you, that's enough of that. Let me get you to move on to, Yes, internal page 21.
21?
Internal page 21 of your revised list. Now, if you look at lines, let's start, there's a sentence that begins on line 13 and continues through line 60. You might just read it. Now, am I correct that you do not actually have personal knowledge that EPA decades ago, as part of the Texas SIP, approved TCEQ's definition of fact?
TCEQ, SIP, been approved by EPA for years.
I understand that, but that's not the question that I asked you, Mr. Nichols. That's not even what you said in your statement. So the question is, you don't have personal knowledge that EPA has ever approved the Texas definition of SIP. Texas definition of fact in SIP, excuse me. Correct?
Just like this, the way you're stating that question, it's not
I'm sorry, did you read what?
didn't read EPA's approval of Texas SIP.
Mr. Nichols, what, can you tell me what microphone number?
4493.
See if I can raise it just a little bit without. Okay.
Mr. Nichols, I believe, you've got an impressive resume in terms of period work in Texas. Roughly 20 years, I think, that's my correct.
Yes, sir.
Are you aware that Texas has had different definitions of the ACT in that 20-year period?
Definitions of EACT.
Yes, sir.
Allow in terms of the EACT changes for various types of facilities in the country.
No, I wonder if you're aware that during the period of your 20 years work in Texas, Texas legal definition, the regulatory definition used by TCEQ has changed. Let me get you to elaborate for us a little bit, if you could, on your view of why you would consider the Tier 1 fact evaluation in Texas to be a case-by-case evaluation. First of all, let me not put words in your mouth. Do you believe that selection of the ACT based on a Tier 1 evaluation in Texas is a case-by-case fact determination?
Yes, we do.
Now, in this particular case, in the Vulcan case, am I not correct that the ACT for, let's say, the primary crusher was determined by looking at TCEQ's matrix for emission rates for a state field, that's what we care about, for emission rates in primary crushing?
Well, the first thing we do when we're doing an application in terms of EACT, we look at the plant as a whole. And look at where it's gonna be located on the site. Determine whether we feel like EACT, as it's going to be described as a Tier 1 level on the matrix, is going to be adequate for where that plant application.
Okay, so let me ask you then, you referred to this matrix, and you just explained, you and I know what you're talking about, but I'd be surprised if somebody else does. Can you explain to the judges what this matrix is, to which you were referring?
Yeah, there's a table
said that this describes the minimum DACT controls, is that correct in that table? And am I correct that that is what you, or what Westward, on behalf of Vulcan, looks to determine, what the control emission rates, what the control technologies are involved in, correct? For your property.
That's the initial,
And indeed, the values that were in that table are the values that are now in the mayor, or are now in what's gonna be executive director's exhibit 9, the draft permit. Correct? Correct. So, no case, well, so then I'll get back to the part where you're going to tell us how that is a case-by-case determination.
well, yeah, once we use, I said we take the, experience of the land size, what we do, production rates, and how far it's been from the property, those things are going to impact a lot of the business. Look at that, in case of this plan, look like minimum DACT suffice. So, these emission calculations, we're gonna have to modify. Our results show that it impacts the property line, that's the sewer limits. So, it showed that DACT chose to take specific case of that.
Well, now, okay. Do I understand correctly that it is the fact that, food concentrations at the property line were acceptable, were low acceptable? That is the fact that drove your determination that DACT had been applied, for control of those emissions back upstream at the facility?
That was part of the, yes. Our experience in working with these plants, my experience, doing emissions tests and watching these plants operate for many years, is that, basically, it's a tier 1 process, water degrades is 70% control, growth control, pressure.
So, in your experience, it means that what I referred to in my opening statement as that second prong of the Texas permitting standard, that a facility using those standards will meet, will not adversely affect off-site health or off-site property. Correct?
Under this particular circumstance, yes. That's my own experience.
Well, what other more protective, technologies or processes did Western consider applicable for this plant? And I presume reject. What other ones did you consider and reject?
Well, other, controls that are typically used on plants like this, partial enclosures, like drop points, partial enclosures of that natural basis, pressures. And in fact, there's a high likelihood that what I would have for the client, when we take credit for emission calculations, we more conservative, higher emissions,
But doesn't that leave you then with a selection that is not the maximum reduction of, let's talk about particular emissions, that would be technically feasible and economically reasonable? Didn't you end up selecting the maintenance value rather than unachievable and financially feasible, financially reasonable alternative?
Your Honor, yes.
Westwood did some, air dispersion modeling using these minimum standards that you described in the matrix. And that dispersion model demonstrated that off-site impacts would, not adversely affect health or property, right? Now, my question is as to the other prong of 382.0518. And that prong is that, am I not correct, that the facility will use, best available control technology? But am I also correct that Vulcan is not committed to use any technology any more protective or any more that more reduces emissions than the technology that is set out in the TCEQ matrix? And if you do, if you on behalf of Vulcan, not to say if Westward's environmental on behalf of Vulcan, do any analysis to determine whether or not, let's say, baghouse filters on the crushers and the screens would be technically feasible?
Well, baghouses on these pressures, this is the core pressures. So we would technically, put them on, because we're not able to move around. When it's built on that, it's running on the chassis, on conveyors, moving the pressures that are all back on the chassis. So we have to truck, site.
So I would move to strike his answer is not responsive. And what I want to know, I'm sorry. So, Mr. Nichols, what I want to know is if Westward, on behalf of Vulcan, did these sort of technical feasibility analysis on, for example, like the gate, with the baghouses or the crushers and the screens.
Technical feasibility analysis is what I just said.
And my question was, did Vulcan do that, or did
Yes. I did. We did that when we did the application.
now it's not reflected in the application, am I correct?
No, we don't have to report the tier one. Tier one is, we did, consider negative possible. Instead, in this case, all the results are so far.
Tier one. And then how about enclosures or even partial enclosures, three-sided enclosures of stockpiles? Was that, did you, for the same reason, did Westward also not conduct any sort of feasibility analysis on those types of controls?
When we do these permits every day, feasibility analysis is just part of our permit application. It's not feasible to put three-sided walls around stockpiles 9 to 45 feet high, and 5 acres. We're not aiming to do that in such condition.
And again, Your Honor, I would move to strike his answer is not responsive. But it's true, isn't it, that in this particular case, there was no such analysis conducted. We simply went to the TCP matrix. Hey,
Our experience tells us that we don't need to do an analysis of the whole This is not a
and so in this particular case, you did no such analysis.
You could say we did no analysis, but my response is that we need an analysis.
that analysis you described. Yep. Let me get you to look real quickly at page, these are on page 27. Okay. And you can read it if you want to, because I don't want to mistake. So I want you to read that last sentence that begins on about line 25. No, just read it yourself, and I'll ask you a question about it. So, am I correct that it's your opinion that, there should be no, in Texas, there's just no regulatory duty to explore, technologies more protective than, the technologies that are described in this, what we call the matrix or table for rock crushers? And that table, or matrix, reflects the acceptable BACT variable for any rock crusher at all. Well, any rock crusher, any Central Texas portable rock crusher. How about that? Is that correct?
Yeah, the construction aggregates, crushing facility.
At the top of, so switch over to page 37. Let me ask you a couple of questions about this. Page 37 of History of Texas. So you can see right there at the top of the page, you're welcome to read that first couple of lines. But I think I'm fairly characterizing your opinion to be that the monitoring and record keeping requirements of the permit as draft permit as drafted. So what will ultimately become ED 69 is that those record keeping and monitoring requirements are adequate to ensure that Vulcan will comply with that permit, right?
Adequate to ensure Vulcan will comply with the
Yeah, there's adequate record keeping and monitoring provisions in the permit. So that one can be confident that Vulcan is complying. Or no?
Yes, that's right.
Well, so what about the trying to find my notes on it, but I know there's a position in this permit that, that if liquid fuels are used, the sulfur content will be no more than 0.0015% by weight. Now, there's no monitoring for that, is there? In the permit, no monitoring for it?
That number, .0015, is the, NA number, sulfur, as far as, monitoring, it's not required to sample that however, decided once the gas
But there's just no monitoring at all, for example. On, for example, the sulfur content of liquid fuel, right?
imagine some monitoring being done, manufacturing, so they would make
But that maintenance facility is not a co-permittee with Vulcan, correct? So the permit right now doesn't require anybody over TCEQ, doesn't require Vulcan to monitor, for example. Let me ask you about fence line monitoring. Am I correct that Westwood's position on behalf of Vulcan is that fence line monitoring is certainly not required by TCEQ for this particular operation?
When you say fence line monitoring, you're referring to the emissions fence line monitoring, or some other type of fence line?
Well, why don't you look at page 40 if you read off that. And down at the bottom of the page, starting on line 20. Okay. You on behalf, and I'm not correct, but you on behalf of, Westward on behalf of Vulcan, says that the permit should not require ambient fence line monitoring.
Correct. This type of monitoring is refers to as location detection, sample device.
And then, am I not correct, that the next sentence down, or the next paragraph down says, that the basis for your belief that, the permit should not include ambient fence line monitoring is that TCEQ regulations do not require ambient fence line monitoring. Well, okay, so that's one of the reasons. Let me ask you about that one. Why is the absence of a requirement a justification for not undertaking something if it were technically feasible and economically reasonable to do it?
Well, notwithstanding economically reasonable portion of your statement, TCEQ sensitive to the fact that they issue all these permits, and permits should be fair and equitable from one time to another. There's no reason to believe that
but again, we don't have any data in this case, do we, to indicate that fence-line ambient monitoring is not economically reasonable or is not technically feasible. Westford is going to undertake that examination, did it?
That's like monitoring would be a PhD research. You refer to
Okay, is that peculiar to the Texas TCEQ definition? That is, if we were dealing with a major facility, that would still have that same opinion?
We deal mostly with minor sources, so, major source.
Are you aware of any prohibition in either statutory or regulatory restraints on TCQ that would cause us not to have an ambient fence-line monitoring requirement in the burn? Is there some law or regulation that would prohibit that?
Sure. One of the special conditions does state that upon request of the executive director or the regional air manager, Vulcan can be required to install ambient air monitors around the baseline. If they're requested to by the TCEQ regulations.
And as you understand it, could that demand be made even if it were not economically reasonable for Vulcan to do that? And with the same, would you also have the same lack of knowledge if I asked you, the technical feasibility question instead of the economically reasonable question?
But that would impact whether TCEQ could request that.
Yeah, would,
I'm not sure what limitations there are on TCEQ being able to request
and do I understand, so, you're welcome to slip back here to page 57, if you care to read the testimony. But, and starting perhaps in the bottom of page 56, that last sentence, or last couple of sentences on page 56. Continuing over through the end of that first paragraph on line 4 of page 57. I don't want to put words in your mouth. I read that to tell me that Western believes on behalf of Vulcan that the fact that quarrying operations and roads are not facilities. Do you agree with that, right? You agree quarrying operations and roads are not facilities. And because they are not facilities, it is Western's position on behalf of Vulcan that including emissions from those quarries and roads in the dispersion modeling is not required. Correct?
As I understand the question, it's not required.
Now, is there any logic behind that you can explain to us?
Texas legislature defining facilities potentially excluded quarries and roads from that analysis.
Okay, well, wait, let me ask you that question. Am I not correct? Am I not correct that the legislature excluded quarries and roads from the definition of facility, and therefore from the definition of sources that TCEQ may require, for which TCEQ may require permit? Did that what the legislature did?
Yes.
doesn't prohibit the inclusion of emissions from sources that are not facilities.